So, what should tenancy agreements contain? Well, they should contain, I've got a little list here, the details of the parties, the main terms of the agreement, the rent and that, the rights and obligations, and I think it's good, as I said, it's good practice to have a summary of the main statutory provisions that apply so people know that they exist. And if you've got any special clauses for a particular property. So say, for example, you've got a property out in the country, it's got a septic tank, you'd need to have perhaps some clauses about the dealing with that aspect. Or if there's something special about your property, you need to have special clauses about it. Now, an important part of the consumer approach to documentation generally, not just tenancy agreements, is that they are written in plain English. As I said, this is a bit of a challenge to the draftsman. I converted all my tenancy agreements to a plain English format a few years ago. I was involved with representing a client who had applied to Crystal Mark to have his tenancy agreement turned into a plain English version, and I represented him during that. And I started off being very sceptical about it and thinking it was all a bit silly. Because one of the big things that you do is you change it from saying the landlord does this and the tenant does that to we will do this and you will do that. And that's a big part of the plain English approach. And after a period of time of working with them, it's a bit of a Damascus Road moment. And I thought, well, it really is important. It does change the emphasis of the agreement. And it is important for it to be easy for people to understand. So I think they are very important. And all of mine are in a plain English format now. Now, one of the confusing areas of tenancy agreements is the unfair terms in consumer contracts regulations, which do apply to tenancies. These were brought in initially in 1995, and the regulations were amended in 1999, and they apply to the standard terms of the tenancy, and there are certain core terms, which is the names of the parties and the term and everything, which they don't. And these basically say that if a clause changes the consumer's rights under law, unless there's a good reason which is explained in the tenancy agreement, this will be unfair and unenforceable. They were brought in because businesses have an inherent advantage because they've got lawyers and they draft the agreements up, and consumers tend to sign them without reading them and knowing what they are. So it's important that there is this balance and fairness so that the businesses are now can't put what they like. They have to have their agreements to be fair. One of the problems about this is that you don't really know whether an individual clause is fair or not until it's been tested in the courts. So this is another way that tenancy agreements are misleading. You may have a clause which you think takes away the tenant. I mean, for a start, a lot of people won't know whether a clause takes away a tenant's rights or not unless you've got a very good knowledge of what those rights are in the first place. So someone may put a clause in and think that it's valid, but if it takes away the right of a tenant, it won't be. Often we won't know whether a clause is valid or not unless it's gone through the courts. The big case that we had in 2010 wasn't a tenancy agreement case, it was a letting agent's case, and that was the Foxtons litigation. And that was about whether clauses were fair or not. Lawyers drafting the contracts very much need to be aware of that. Let's see, I'm on page 17 of the notes. I'm just going through. So when they consider the effect, the court would look at what the legal rules were before the contract and then see if that contract term changed that, and if it did that significantly, it will be unfair. Now, we've known for quite a long time that the unfair terms in consumer contracts regulations apply to tenancy agreements because there was a case in 2004, London Borough of Newham, which confirmed that. However, we've also had a European court case as well, because these regulations apply across Europe because they come from a European directive. And this case, a Dutch case, Bruce and Garabito and Jahini Limited, I hope that's correct pronunciation, so that confirmed that. And in most cases, a landlord will be deemed to be acting in the course of a business if they rent out property. And even if they're not, they let it out through a letting agent, the regulations will apply. But they won't apply, of course, to tenancies that were created before they came into force in 1995. So let's have a look at the main points of the regulations and how specifically they apply to tenancy agreements. So I've got these set out on page 18 of your notes. And the first one is that if they limit or exclude rights that the tenant would otherwise have had. And again, there's this problem here because you need to know what they are in the first place before you know that they're unfair. There's also unfair penalties. And then there's prohibitions. Now, if you're prohibiting something, there's this wording that you need to put in, which is along the lines of that consent, that the landlord can ask for whatever it is that you're prohibiting, and that your consent should not be unreasonably withheld or delayed. And this wording needs to go every time you're prohibiting something, unless it's something that's prohibited by law anyway. So, I mean, you know, they're not allowed to keep guns in the property or do drug dealing, you know, so it's okay to prohibit that because that's not something that they're allowed to do. Now, the classic example where this causes problems is with pets. And I've put up a clause on the slide there, and most landlords will not want pets in their property. So the clause will say you must not keep any pet or any kind of animal at the property. And then the wording in green is unless you have our written permission, which we will not refuse or delay without good reason. Now, a lot of landlords will say, I don't want pets in my property. There are no circumstances under which I'm going to have pets in my property, so I am crossing that wording out because it doesn't apply. But what that means is, by crossing that wording out, they are actually invalidating the clause, which means that their tenant can have 15 cats and a couple of Dobermans and a few budgies and perhaps a couple of snakes as well, or crocodile. So, you know, you need to make sure that that wording is in. Now, the fact that that wording is there, it doesn't mean that the tenant can have a pet if they ask for it, because you will normally have a reasonable reason for refusing. And there are a lot of reasonable reasons for refusing to have pets. I mean, it could be that you're worried that people coming later on might be allergic to pets. They could do damage. Cats and dogs can do a lot of damage to property. So provided your reason for refusing is a reasonable one, that's fine. You're okay. You've got the wording in there. They've asked, you've refused. It's reasonable. They're not allowed to keep the pet. But don't take that wording out, because if you do that, you're laying yourself open to having pets. Now, the final type of clause is one which is difficult to understand, legal terminology which isn't in common use, or words which have a specific legal meaning. You have to be careful about using these, and if you do put them in, you need to do a little translation afterwards saying what the words mean, and they'll be okay. And the general appearance and usability of the agreement is also covered by the unfair terms in consumer contract regulation. I remember years ago there used to be, I think there were utility agreements. They'd been printed in very small font in pale blue on white paper. Now that's very difficult to read, and I've noticed that in recent years we haven't seen those anymore. Don't do your tenancy agreements like that, because it may make the whole agreement invalid. Now, the Office of Fair Trading has published some guidance on unfair terms, so if you are ever doing any drafting work, you need to get hold of this. It can be downloaded for free from the Office of Fair Trading's website, and I've given some directions in the notes on how you can search for it. It was published in 2005, which is quite a long time ago. I understand they are looking at doing another guide, but I don't know if they are when it will be published. So at the moment, this is what we've got. So that's important. So far as enforcement of regulations, the Office of Fair Trading is the body tasked with this, and also local trading standards offices have a role here. And the recent Dutch case that I mentioned said that if there is a case and there is a clause which is in issue, perhaps you're claiming compensation under a penalty clause, this case said the judge has a duty to consider whether the unfair terms in consumer contracts regulations apply, whether or not either party asks for this, because it may be the litigants in person, the tenant may not be aware of these clauses, but the judge has got to consider the regulations and consider whether the clause is fair or not, whether he's asked to or not. And if it's unfair, he will annul it and you won't get your money judgment for compensation if it's under an unfair clause.